Welcome, everybody, to this edition of ChiroSecure's Growth Without Risk program. My name is Michael Miscoe with Miscoe Health Law, and today we're going to talk about something we've talked about in the past. I checked my records not since 2019, and I think from some questions I've gotten recently, it's probably time to redo this again. But how to deal with record requests. There's a number of issues when you get a request for records that you have to consider, and this should be a process for which you should have a policy. And that policy should address a number of things. The first being the HIPAA issues that you have to consider when getting a record request. And essentially, um, with the patient's acknowledgement of your notice of privacy practices, you are allowed to disclose information for purposes of treatment, payment, or healthcare operations. A treatment request would be a request from another provider, healthcare provider, and you don't need any special authorization for that. Payment, those disclosures, meaning information necessary to secure payment from a insurance company. Minimally, that would be the information on your CMS 1500 form. Obviously, you don't need an authorization from the patient every time you send a bill. In healthcare operations, which is where you normally see requests for post-payment related audits. Now, a payment request could be a prepayment request for records, meaning they request the records to evaluate the appropriateness of payment before they make payment. And disclosure in that respect of information relative to the service you're trying to get paid for is certainly permissible. On the post-payment side, however, is where you have to be a little bit cautious under HIPAA, because HIPAA has a component to the rule known as the minimum necessary disclosure rule. And with the changes in the HITECH Act, Healthcare Information Technology and something Act some years ago, they made a change to the minimum necessary disclosure rule where previous to HITECH, you were permitted to rely on a insurance company's request as meeting your requirements under the minimum necessary disclosure rule, which means when you get a request, you're obligated to provide the minimum amount of protected health information necessary to serve the purposes of the request. So when an insurance company pre-HITECH asked for the entire record, you could presume they needed it for their purposes. After HITECH, you can no longer assume that. So the purpose of the record request has to be disclosed in the request, and it often isn't. What happens is payers traditionally request over disclosure. Maybe because they're on a fishing expedition, they don't know necessarily what they're looking for, and they'll request things like the complete chart. And if you think about that, in your experience with a patient, it's not always the case, and in many cases, it's very unlikely to be the case, that your entire history with this patient has involved services that were billed to this particular insurance company. So when you get a complete chart request, at a minimum, you got to remove anything that does not pertain to billings to that particular carrier. So if there was a prior personal injury case, maintenance services for cash, all of that information would obviously have to be removed because it couldn't possibly pertain necessarily to billings to that particular carrier. Um, Beyond that, think about the purpose of the request as being maybe they're looking at coding, in which case the treatment notes would be the only thing you need to disclose for specific services that they're actually auditing. Um, Otherwise, it may, if medical necessity is on the table, then possibly a more expansive disclosure. When they don't disclose the purpose of the request, technically there should be some resistance to just giving up everything you have and requesting more information about the purpose of their audit. And it's one of the techniques that we use to slow the process down. Now, of course, we don't want the carrier to get nuts about this, but if we can make a legitimate objection, um, you know, or at least raise the issue, this is the presumed purpose of your request, and therefore we're disclosing this information. We reserve the right to amend the disclosure if it turns out you're looking for something else. But at least you give yourself the ability to provide something more. In many cases, payers want you to sign an affidavit, if you will, or an attestation that you've disclosed everything. Rarely do we do that. We instead provide a different type of attestation. We've disclosed what we believe is consistent with the purpose of your request, um, uh, consistent with our obligations under the minimum necessary disclosure rule. If this disclosure is insufficient, depending on what your actual purpose is, we reserve the right to get you more information, and that's how we handle that problem. Now, in many cases, I'll get calls from providers because they get requests from usually a third party auditor on behalf of a Medicare Part C plan or a Medicare Advantage plan, and it's the purpose of the request is so that they're doing risk validation. And essentially, what those requests are, they need your information to validate the risk adjustment score that the Part C plan has submitted to Medicare for that patient. Those requests have nothing to do with you, and you can submit your record information to them because it has, like I said, it's not an audit of the compensability of your services, but they're looking for diagnostic information in order to validate the risk adjustment score that the Medicare Part C plan submitted to Medicare, which is part of how they get paid, uh, or it impacts the amount that they get paid to provide coverage to that particular insured. So if you get a risk adjustment audit, you see language that says risk adjustment or HCC risk validation. Those requests you can respond to without much in the way of concern. The other issue that you need to consider when you get a record request is your participating status, because this implicates, and maybe I should have addressed this first, whether you have to respond at all. Now, certainly when you're a participating provider, your participating provider contract usually includes language that obligates you to cooperate with their utilization review, post payment review, quality analysis, whatever they want to call it, but basically their post payment audit process. And that's fine. And you have a contractual duty to respond to that request consistent with your obligations under the minimum necessary disclosure rule of HIPAA. The more interesting scenario is when you are non-participating with the particular carrier. In those circumstances, you should probably call and get assistance early on, because there are defenses that can be raised that would mitigate your need to submit any records at all. And essentially, not to get through, the rather complicated legal doctrines that influence this issue, but fundamentally, absent a contract, you usually have no legal duty whatsoever to comply with those requests. Now, that doesn't mean I'm suggesting that you ignore them, because when you do, oftentimes those payers will just deem those payments to have been in error and start recouping. So you do need to respond. It's just how you respond. With some early intervention, usually those audits can be put to bed with minimal blowback. There potentially is some negative consequences that can occur if we decide not to cooperate with their post payment request, but at least you can establish a legal basis for why you're not obligated to. As far as HIPAA is concerned, just because you're permitted to disclose under HIPAA creates no legal duty to disclose except to the patient. So when a carrier is doing a post-payment analysis or attempting to do that, oftentimes submitting the records, compromises some of your legal rights, and we need to, you need to, with competent legal counsel, evaluate whether it's in your best interest to disclose or to resist disclosure. Now, when you're participating, here's a couple, and you have an obligation or a legal duty to disclose by virtue of your participating provider agreement. There are a couple of things that you need to consider as you build your package of information to disclose. The first thing you have to consider is what to include. Now, in some cases, the payer will be auditing specific dates of service because of a particular billing pattern. So in their sample, they've identified, let's say they're evaluating claims as their sampling unit. So they'll identify specific dates of service for specific patients. And in many cases, the provider will provide that individual soap note or treatment note because those are the dates they asked for. If medical necessity is at issue, or the reason why you're billing certain codes, how that's justified, oftentimes in order to explain that, it makes good sense to provide the initial uh, evaluation, treatment plan, treatment order, that type of documentation, maybe interim progress evaluations, so that they can see the purpose of the treatment that's being performed on the encounter that they're evaluating. Sending one soap note out of the middle of a course of care is like giving you a page out of a book and asking you to understand what the whole story is about. Very difficult, and you have to evaluate those requests carefully to see if it makes sense to include more than the date of service that they're asking for. In some cases, it makes sense for the provider to prepare summaries explaining or providing additional information if your records are a little weak relative to explaining the specific nature of the therapies performed. Location, let's say it's electric stim, where the pads were applied, what frequency, ramp time, duration, the purpose of the electric stim. Oftentimes, I find that providers, EMR programs, do not fully describe that in the context of a treatment order, in which case you can supplement your uh, information with a summary that explains that. Oftentimes, that's necessary for rehabilitative exercise, where you define sets, reps, weight, level of contact, things of that nature. To substantiate specifically what was being done, so the payer can evaluate the appropriateness of that treatment as it was performed relative to the patient's conditions. um, those that information is prepared in a summary, or an addendum, if you will, which includes a signature attestation validating that that information is accurate, and that is done in lieu of modifying the original record, which you should never do. um, the process of creating addendums is fully disclosing that this was prepared in response to their request, which means the date that that information was prepared is fully disclosed, and that its purpose is designed to further explain uh, what the contemporaneous meaning the record that you created at the time the service was performed, to provide more information than was disclosed originally. The payer can accept, reject that information. They're obligated to consider it. Some auditors will say, well, that was prepared after the fact, therefore we're not going to consider it. Those are issues that get fought out ultimately in the end. But assuming the information is true and accurate, consistent with the attestation that would be sent with it, then they should consider it, because, I mean, ultimately, what you did and why you did it, it is what it is. The purpose of these audits is to find out whether the services were actually compensable or not. Sometimes the credibility of that information can be challenged, but if it's something you know to be true, and you need to provide supplemental information to your original records, that is the way you do it. Get help with preparation of those so you do it the right way. Because if you do it the wrong way, you can turn a simple post payment audit into a criminal case. Seen that happen a number of times, and it is very difficult, expensive, and time consuming to get that horse back in the barn. So be very, very cautious. I do want to emphasize this issue of alteration of records, because it is especially problematic. A provider gets a request, recognizes there are potential defects, even errors or omissions in the record, and the natural reaction is to fix the record. If you use an EMR, you want to go back in and edit the record and make it all right, so that in your mind, you're giving the payer accurate information. The only thing that's inaccurate about what you would be supplying when you alter the records is when the information was created. And that is, trust me, a really big deal. And if they figure it out, which they are likely to do by any manner of ways, if for no other reason, if your EMR program has audit tracking, they can track metadata in your EMR system when they suspect that that's an issue, um, especially where the alteration is somewhat consistent. and not so much patient specific, you're likely to get caught. Please, 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 please do not ever do that. Your natural reaction to fix the records needs to be overwritten by common sense, recognizing you don't want to risk criminal liability over an issue that's just about money. There's a better way to do that. Get help with respect to supplementing your records with addendums or treatment summaries if you think medical necessity isn't well explained in your records, providing how information about how the treatment actually influenced the conditions that the patient presented with. But there is a much better way to do that than trying to fix the records that you already have. As I mentioned, that can lead to criminal liability, all kinds of things, obstruction charges and whatnot, that are very, very difficult to defend from a legal perspective. So hopefully that gives you, some idea of the things that you should consider. Anytime you get a record request that's not a risk adjustment audit, I certainly recommend getting assistance, with that process of preparing the records, because if done correctly and completely, it gives you the opportunity to sidestep issues, where you have a legal duty to produce the records, i.e. when you're contracted, or if it's Medicare or a government program. When you're not contracted, then there's some additional things that you should discuss with counsel, and evaluate the risks and benefits of doing a disclosure or resisting the disclosure. So that's all we have time for today. Next week, Dr. Sherry McAllister's up, and I'm sure she'll have something equally or more important to pass on. I appreciate your time today, and we'll see you next time.